So we had a client once who came to our office and he was in a sticky situation. He was a brand new landlord and he wanted to do things the right way, but he was off to a bumpy start. So here's what he did. He started off by purchasing a rental property, and he purchased this property in the name of his registered LLC. Now, when he found a tenant, he signed a lease with that tenant in the name of the LLC and began the lease. Now, about 4 months in, there was a problem. The landlord, after conducting a routine inspection, discovered that the tenant had 2 unauthorized occupants. He gave notice to the tenant, but he did not remove the occupants, so he followed up with a notice to vacate on the basis of this lease violation. By the following month, the matter went to the eviction court, and he presented his case to the court, but the judge kicked the case out. And he did it because upon reviewing the lease, he saw that in fact the lease was between the tenant and the LLC. But this landlord had filed the eviction petition in his own personal name. So the judge said that the wrong party was involved in the case, and he told the landlord, you got to start over. Now that's not where his trouble ended. Remember, we're in month 5 now. It started off with 4 pretty good months, and the rent is current. Even though the parties were headed to the eviction court, that tenant was sure they would not lose the case. And he turned out to be right, because the judge kicked the case out because it was filed improperly. Now, rent was current, but that landlord was really upset. So what does he do? Same day that the case is dismissed, he walks around to the other office, he files a brand new case based on the exact same facts. But this time he files it in the name of the LLC. By the following month, we're in month 6, the matter is set for trial again, and sure enough, he prevails. But here's where things get bumpy. Once he filed the second time, that tenant no longer continued to pay rent. Once the matter came to the month 6, the tenant said, I'm not paying rent until this is resolved by the court. Well, when he lost in front of the court, he appealed and then refused to continue to pay rent. Nor was he required to pay rent, because that eviction was based on the lease violation of unauthorized occupants. You're beginning to see the problem. So the matter proceeds into month 7 in front of the county court, now that the matter is on appeal. And we're here at the end of month 7. This landlord has gone 2 full months without any rent, and that tenant is willing to fight all the way through. The matter goes in front of the county court, and as the trial begins and the judge hears what the case is about, he turns to our client and says, you cannot proceed without an attorney. You filed in the name of an LLC. Are you an attorney? Of course, his answer was no. And so the judge said, I am going to give you 2 weeks to go find an attorney before I dismiss this case. That's when the client came to us. So what was the basis of the court requiring an attorney? Well, in the state of Texas, there is currently a limited reason why a non-attorney can represent a party in an eviction. Generally, it's limited to non-payment of rent. But once you get to the county court, you're extremely limited. It has to be a matter of non-payment of rent, and you have to be a multi-family property. In this case, it was a single-family home, and it just didn't meet the requirements of the code. And because of that, the judge rightfully required that the party go and find an attorney, because the lawsuit was based on lease violations, had nothing to do with rent, even though the tenant wasn't paying rent, and it was a single-family property. And so because of that, the court denied my client the right to proceed before he had an attorney. Now, you might be asking yourself, why didn't he just modify his lawsuit to include non-payment of rent? I want to remind you that when he filed it in month 5, the rent was current. And because it was current, and because he went to trial on a matter not involving the rent, now on appeal, he couldn't amend the petition to simply add a new cause of action. Remember also that the original notice to vacate said nothing about non-payment of rent, and he relied on that original notice to vacate, which only mentioned the unauthorized occupants. So you might be asking yourself, why would I want an LLC if it's so much trouble? Well, it's certainly something you have to consider, is the possibility of having to go into the eviction court and hire counsel to cover the case. But I want to talk to you about the benefits of having an LLC. His original idea was pretty good. An LLC serves to shield you in 2 ways. First, you want to shield your individual assets and your individual stuff, your obligations and your duties, from that of your business. And by establishing a limited liability company, you're able to do this. You have a distinct person, which is the LLC, and then yourself, separated by this legal barrier, so that nothing that happens in your business has any kind of negative effect on you. Any lawsuit that goes against the business, so long as everything is set up properly, will not harm your individual assets. In this case, he signed a lease in the name of his LLC, so that if that LLC were ever sued, so long as he maintained that legal barrier, nothing that he personally owns, his home, his vehicles, his accounts, none of that would be subject to any reach because of that barrier. Now, another function that is served by the same legal barrier is protection between your assets. You may have multiple properties and you want to shield them from each other. You may have, say, 4 rent houses and 4 different legal entities set up so that if any one thing goes wrong in the one, it doesn't tackle all of the others. Imagine if you owned all of the same properties under your personal name and you were sued. Not only are your personal assets at risk, but from one rental property with a large enough claim, all other rental properties could fall in that one litigation. So by setting up these parameters, you leave the other properties free from any kind of involvement. You also remove your own personal property, and any claims raised by an individual from one rent house cannot affect you personally, nor your other business assets. So the LLC serves as a shield in both of these ways, and both of them are wise ways to protect yourself and your other business assets. Now, to maintain this protection, you're going to want to make sure that you never intermingle your funds. Now, what does that mean? Well, the fact that you own this LLC doesn't mean that out of your personal account, you should be paying the bills of that LLC, nor should the LLC's account be paying for your personal bills. If you're unsure how to do this, you might want to talk to a business attorney, you might want to talk to your CPA about how to keep things distinct, but one easy method is to have 2 separate accounts. All the money that comes into the LLC stays for the benefit of the LLC. How do I get money from my LLC then? Well, you as a member of your LLC can receive benefits from that LLC. But remember, these withdrawals or these, and they're called different things in different states, this draw from the LLC should be documented and it should be distinct from all other purchases from the LLC. So that if, for example, every week I derive from an LLC a weekly draw of X amount of money, that's different than if my LLC is paying my car note or is buying my groceries or funding my vacation. In this sense, the LLC is no different from me, the individual. But if instead I get a weekly draw, it is much clearer that I am the owner and am receiving regular benefits, but I'm not commingling my funds. My personal funds are neither paying for the business needs of the LLC, nor are the business funds paying for my personal needs as an individual. This distinction is extremely important because in the event that it is found that you have intermingled with your LLC, you might lose that barrier of protection, and anything that someone is coming after from the LLC, you might be equally on the hook for. And of course, you want always to avoid that. Another thing you can do is make sure that all of your paperwork clearly establishes that the business activity of your LLC is just that, their activity. Even if you're the one who's physically signing contracts, you should be cautious to always sign as a member or an owner of that LLC so that it is clear that you are not accepting personal liability. Instead, you are obligating only the LLC. You are there as its representative. You sign contracts as member of this LLC. You make agreements, you communicate as a member or an agent of that LLC. Your email communication should be clear that it's not coming from your personal account, it's coming from an account owned by the LLC. Your written letter should also feature the name of the LLC, not coming from you personally. You are merely an agent of that LLC. So long as your paperwork is clear, it is clear to all others that you are not personally involved. Instead, you function only as an agent or a representative of your LLC. Finally, what does state law have to say about non-attorney representation when it comes to an LLC? Well, as I mentioned before, it was a little bit confusing, and many people, even people who tried to look up the law to see what it said, were often confused by what it required. Essentially, if it had to do with non-payment of rent or it had to do with a multifamily, you could probably get by with an authorized agent of the LLC. However, come January 1st of 2026, the laws in the state of Texas will change. And that change will make things actually quite clear for non-lawyer representation, particularly when you have your own LLC. And here's a basic breakdown of the new law, again, starting January 1st, 2026 in Texas. When it comes to the Justice Court, everything goes. A non-lawyer agent representative can represent an individual or an entity for all matters. And so you're no longer restricted to just non-payment of rent. You can bring a lease violation claim as a representative of an individual or an LLC or a corporation or a limited partnership. In the Justice Court, they let everything fly. However, once the appeal is in effect and it goes up to the county court, that's when another limitation kicks in. And so if you have an entity, you are allowed to appear with a non-lawyer representative, including you, the member of that LLC, to present the case, or really any authorized agent of the LLC. But it is limited to lawsuits for eviction for non-payment of rent, and limited to multifamily residential property. So if this is a commercial matter, doesn't count. If it features non-rent lease violations, can't do it. If it's a single family home, unfortunately, not available to you. So again, in the Justice Court, where the majority of cases are heard and come to an end, you can do it. You can send an authorized agent. You don't need to have an attorney appear on your behalf. But once you get to appeal, once you get to the county court level, unless you have a cause of action for non-payment of rent and you are a multi-family residential property, all other matters are we're going to require you to be represented by an attorney. No one else can represent you in an eviction in this case. So back to my client who came to me with this terrible, terrible situation. Not only had they found themselves needing an attorney, which we were able to fulfill and able to step in. But there were other problems that came from the paperwork. Turns out that the original notice to vacate came not from the LLC, it came from the individual. He didn't even mention the LLC. He signed it in his own name, never mentioned that he was a member of the LLC, the landlord that signed the lease. And so there was that problem. Additionally, my client was losing rent and could not demand rent from the court. So he was in a tight spot. Here we are now into month 8, and he still hadn't received rent for month 6, month 7, or month 8. And there was a pretty good possibility that even with an attorney, with that defect on his notice to vacate, that he was gonna have to start the process over. And in that process, he could claim non-payment of rent, but man, was he gonna be pretty upset having lost 3 months of rent on top of all of that. Fortunately, we were able to work out a deal with that particular tenant. We were able to negotiate a plan where they would vacate and that we would dismiss the case against them. Again, when it came down to it, it had pretty much no value. Maybe he would be able to recover attorney fees, but that was if and only if we were able to prevail on that pretty weak notice to vacate. So when you're using an LLC, there are some great advantages to it, but you always want your paperwork to align properly with it, and you never want to intermingle your funds with your LLC. If you're considering using an LLC in your rental business and you've learned a thing or two, we'd appreciate a like. Any questions or comments, leave those for me below. I'll answer them myself. And if you're not yet a subscriber, what are you waiting for? Go ahead and subscribe. The landlord-tenant business can be a bit complicated, and occasionally it gets more complicated when we don't exactly know the full extent of the law or of the benefits that are there and the requirements that we have to meet before we can take advantage of those benefits. However, it's always true that if you're unclear about something, there are people out there who can help answer questions before you find yourself in a bit of a mess. One of those places is this channel right here. And YouTube seems to think that this video right here is the next best thing for you to watch. We recommend that you check that out along with the rest of our catalog of videos. And until next time, landlords, happy leasing.